Court does call the case of the people of the state of Michigan versus Philip Carrick.
And is that on behalf of the people, Your Honor?
Good evening, Your Honor. Sam Bernstein with on behalf of Mr. Carrick. Appears by Zoom.
And this is the people's motion to modify bond. So you may go ahead.
We're jumping straight into a high-stakes bond modification hearing in the state of Michigan, and right away, you can feel the tension in the room. This isn't just about paperwork or technicalities. This is about whether a man accused of repeated domestic violence, strangulation, and unlawful imprisonment should remain out on bond or face far stricter conditions. The prosecution is asking for $500,000 cash surety and home confinement. It's pretty tight. And when you hear the allegations laid out, multiple assaults, choking incidents, threats to kill, prior domestic violence cases, you start to understand why. But here's the twist. The defendant was already on bond in another domestic violence case when these new allegations surfaced. That changes everything legally. Courts take repeat behavior while on bond extremely seriously because bond is essentially a promise to behave and follow court orders. If you allegedly reoffend while on bond, that undercuts the court's trust. So the big question becomes, is the current bond sufficient to protect the community, or did the magistrate go too easy? And by the end of this hearing, Judge Simpson is going to answer that in a way that significantly changes the stakes. Stay close. The legal mechanics here matter.
At this time, we'd be requesting our original request of $500,000 cash surety, as well as if he is to post or be released for a home confinement tether. Your Honor, I'm not sure if the court had enough time. I know we submitted this late last night to the court, this motion, so I'll kind of go through it a little bit. Your Honor, in the instant case here, to start out, the entirety of the events of this case from March to July occurred while the defendant was either on bond for a strangulation or after he had pled to a DV second in Judge Kunke's court. In this case, the victim has laid out a series of assaults starting in March through July that include the defendant assaulting her in a numerous variety of ways, including kicking her, throwing her down, punching her, biting her, and choking her. And in some of these events, some of these specific events that stick out to the people, Your Honor, include an event where the defendant is alleged to have strangled the victim and taken her keys and her phone and had been sleeping by the door to hear when the victim tried to leave the apartment. She did attempt to leave the apartment. He then chased her down out in the parking lot, bear hugged her, and then told her that if she were to make a scene, he would, I'm sorry, Your Honor, the correct quote that she was stating, that if you make a scene or you scream out, I'm going to effing kill you, and then told her to get back into the apartment.
This is where the emotional gravity of the case really lands. The prosecution isn't just listing charges. They're describing a pattern of control, confinement, and alleged strangulation. And legally, strangulation allegations are treated with extreme seriousness because loss of consciousness can occur in seconds. When the prosecutor mentions that the victim allegedly went unconscious, that signals potential lethality. In domestic violence cases, by prior strangulation is one of the strongest predictors of future lethal violence. Notice how the prosecutor emphasizes the hospital visit and photographs of injuries. That's strategic. Visual evidence strengthens credibility at bond hearings because judges are assessing danger to the community, not guilt beyond a reasonable doubt. And here's the broader point. Bond hearings aren't mini trials. The judge isn't deciding whether the defendant is guilty. He's deciding risk of flight, and risk to victims, risk to the public. When you hear about threats like, "You're not going to see your children tomorrow," that's not just dramatic. That speaks to intimidation and coercion. The question becomes, if these allegations are accurate, can bond conditions realistically prevent further harm? Or is the pattern too entrenched?
Your Honor, after that, I also have concerns that at one point she was strangled to the point of unconsciousness, which in our eyes is mere seconds away from death. And she did have to go to the hospital and get treatment. Your Honor, along with this report, there are numerous images of injuries that she sustained, including bruising to her arms, bite marks, bruising on her neck, as well as a extremely large, I would say, bump on her forehead from these assaults from this defendant. He has threatened her numerous times throughout this case. In one of the points where he was strangling her, he told her she wasn't going to see her children tomorrow. She's had a black eye from this defendant. I also have concerns in this case that it occurred while he was on bond. He has a previous history of domestic violence, and in one of those cases back from 2023, he had picked up a case of domestic violence with a victim. While on bond for that case, he saw her at a bar and assaulted her again for that case. And in that specific case, the assault that he did left bruises on his victim. He had put his hand around her neck and a pillow over her face during the course of the assault. And she was so afraid and traumatized from this assault that she had fled the apartment the following day and then fled the state. And then continuing on in his criminal history, he just pled in a case for a second, which includes pretty similar behavior of strangulation and domestic violence. He's continuing this pattern of aggression and abuse towards women, and it seems to be escalating in this case, which has led to these charges of unlawful imprisonment, GVH strangulation, as well as domestic violence in numerous instances. I have great concerns. I also have concerns that in this police report, she also alleges other violations of bond of him being at bars drinking, which was against his conditions of bond, and that also matches what the victim impact statement was in Judge Kunke's court, that she saw him at the specific bar that the other victim mentions he was at that time. I mean, I have great concerns that he cannot follow court orders. He is a danger to the women around him and a danger to the community. I mean, he continues to not follow court orders, assault women, and I have extreme concerns for the community's safety as well as just women in the community in general, given his behavior. He cannot follow court orders and continues this pattern of aggression and abuse against numerous women. He now has 3 different victims of domestic violence against him. It is a pattern of behavior that's extremely concerning to the people. And I believe our request of $500,000 cash surety as well as home confinement is helping to protect the women of our community from his abuse and aggressiveness towards them. I'm sorry.
Yes. Was it yesterday this defendant was sentenced?
He was sentenced, Your Honor, on Tuesday.
On Tuesday.
To domestic violence second offense. This report came in on, I believe it was made on Monday. We did not receive it till that morning / afternoon on Tuesday.
So, and that's what I just have one question. So Judge Kunke, when she sentenced him to I think it was 1 year probation or something like that, was not aware of?
She was apprised, Your Honor, of what was in the process of going on. And at that point, we had tried to get this complaint sworn to and have officers present to initiate this case. However, we wanted the other case to proceed as it was up for sentencing that day. So Judge Kunke was apprised of what was in the process of happening at sentencing.
Got it. Okay.
And I also wanted to note for the court as well that the context of these events at the beginning starts after the defendant's tether had been removed in the previous case after exam. That's when the beginning of these events start up until July of this year before he was sentenced.
What do you mean his tether was?
He was on a tether in the previous case, Your Honor, at the start of that DV case. And after exam, there was a motion for the tether to be removed and the tether was removed. I believe it's a hot zone tether in that case.
And then the behavior begins.
Correct.
Your allegation. All right. All right. Ms. Bernstein, respond.
One thing I want to point out, Your Honor, is that in the emergency motion, it states that the magistrate gave Mr. Carrick a $50,000 cash or surety bond. That's not actually what the bond is that the magistrate gave. He gave a $500,000 bond with a 10% privilege. And there is actually a significant difference between the two in terms of the amount of money that is required for him to get out. So at this point in time, he posted a bond, which required paying a bail bondsman $12,500, which he can't get back. And so the bond that's posted for him right now is $125,000.
Now the defense pivots, and this is classic bond strategy. They're not arguing innocence here. They're arguing numbers. The defense clarifies that this isn't a $50,000 cash bond as stated in the prosecution's motion. It's a $500,000 bond with a 10% provision. That's a massive difference mechanically. Here's the breakdown. A pure $500,000 cash bond would require the full amount up front. But with a 10% provision, the defendant can post 10%, often through a bondsman, meaning significantly less cash is required immediately. According to defense counsel, that required $12,500 to the bondsman, with a posted bond amount of $125,000. That's not insignificant, but it's far less restrictive than full cash surety. This is where legal nuance meets public perception. $500,000 sounds enormous, but the 10% privilege dramatically lowers the practical barrier to release. So ask yourself, should someone accused of committing a new offense while already on bond receive that 10% privilege, or does that undermine accountability? Because that precise issue is about to become the focal point of Judge Simpson's ruling.
So it's not an insignificant amount by any means, and it's much, much more than what would just be a $50,000 cash bond.
So what you're saying is the bond is set by he's posted?
It's posted, Your Honor. I think he's being held pending this emergency motion.
Yes. Okay.
What I think, but I mean, my point there is that it's actually much higher than is stated in the motion. I know it sounds similar, but mechanically it actually is much more difficult to post that as 10% of $500,000 rather than a $50,000 cash surety bond. So it's not small. At the arraignment yesterday, Magistrate Odetella did say that he had participated in the swear-to. He had heard everything that has been said now. He had also reviewed the bond recommendation form as well. So there hasn't been anything stated that's different than what was given to Magistrate Odetella yesterday. And nothing has changed since then as well, Your Honor. Submit to the court that the bond in place is actually quite high, and it's not an abuse of discretion to give that type of bond in that amount. It's not a low amount by any means. It's different than $50,000 cash or surety. It is a significant bond, Your Honor, and I don't think Magistrate Odetella abused his discretion in setting that bond.
But he was on bond at the time of the occurrence of this offense, correct?
That's the fact pattern, Your Honor.
Yeah. Okay.
And Your Honor, there was one more thing I wanted to add as well. I know it came up in arraignment about the timing of the report, but I did want to say in the report, the victim states to officers that she had come in to report this because of her daughters and her children, and that she cared about the defendant as a person, but was terrified of him and what he's done and did not want her daughters to have to go through that as well. And that's why she came forward. It wasn't with malicious intent.
Anything else, Mr. Murphy?
What I would ask the court to take into consideration if the court is considering raising the bond at this juncture is that he has committed significant reliance on the bond as it was given yesterday. And so we'd ask the court to please take that into account when considering a bond at this point in time.
The concern that I have is that he's on bond for a domestic and this occurs.
Here's the moment the temperature changes. Judge Simpson is no longer just listening. He's signaling concern. And notice what he zeroes in on. The defendant was already on bond when this alleged offense occurred. In Michigan, committing a new offense while on bond can justify revocation or denial of bond altogether. The judge even hints at that possibility when he says it may entitle him, quite frankly, to no bond. That's serious judicial language. Yep. Then comes another critical factor, the tether removal. The judge points out that once the GPS tether was removed, the alleged behavior escalated. From a risk assessment standpoint, that suggests supervision mattered. Remove supervision, and the pattern allegedly resumes. Legally, bond is about conditions sufficient to protect the community. If prior conditions didn't work, courts escalate. That's progressive restriction. And this is where it becomes clear. The 10% privilege is in jeopardy. The judge is weighing discretion. And whether granting that reduced cash requirement was appropriate under these circumstances.
I'm also concerned that the defendant seemingly gets off a tether and then the behavior begins to escalate, which is, I think, in a certain respect, for this court problematic, and I think should have been taken to the extent the magistrate knew, should have been taken into further account. I also am not sure because, frankly, I don't believe that, given the fact that the defendant was on bond, which may entitle him, quite frankly, to no bond, because he was on bond at the time of this offense. The magistrate chose to give him a bond, but I believe the granting of the 10% privilege is certainly problematic with all of those other circumstances before, meaning that if he's on bond certainly, I think it's an abuse of discretion to give them the 10% privilege on the bond. So the court will grant the people's motion. Yes, I will grant the people's motion. The defendant's bond in this case will be modified not in terms of its cash component of the $500,000. I will leave that in place, but it will be cash or surety, no 10%.
There it is, the pivotal ruling. Judge Simpson keeps the $500,000 amount, but strips away the 10% privilege. That changes everything. Without the 10% provision, the defendant must post the full $500,000 in cash or surety. That is exponentially harder. This is the judge sending a clear message. The original bond structure was too lenient given the totality of circumstances. He doesn't revoke bond entirely, but he tightens it significantly. That's judicial balancing, not maximum punishment. Yeah, but heightened protection. He also modifies the release terms to home confinement tether instead of general GPS. Home confinement is stricter. It means you're at home unless specifically authorized, likely for work only if approved. From a legal standpoint, this reflects proportional escalation. The court is saying, if you allegedly offend while on bond, you lose privileges. So here's something to consider. Is this enough? Or should bond have been revoked entirely? Courts must balance presumption of innocence with community safety. Where do you think that balance should fall in cases like this?
So I'm removing the 10%, but all of the other conditions that the magistrate set in place, the court does find appropriate, and those would remain in place.
So it will continue to be a GPS tether and not home confinement?
If he posts, I would change that to a home confinement. All right, got it.
Thank you.
Could he be released for work, Your Honor?
Pardon?
Could he travel to work? No,
If he posts, I'm going to do it. If he posts, then there would be a home confinement tether. I will certainly take a look at what the work schedule is. I doubt that there would be agreement between the parties as to what that work is. But if he has a regular work schedule or however that is set up, the court will take a look at that and would make an accommodation so that he could work if that's a possibility.
This hearing ultimately centered on one core issue: trust. The court had to decide whether the defendant, already on bond for domestic violence, could be trusted under less restrictive conditions. Judge Simpson determined that while bond would remain available, the 10% privilege was inappropriate given the alleged pattern of escalating violence and prior bond status. The result: a full $500,000 cash surety requirement and home confinement tether if posted. That dramatically increases the barrier to release while preserving constitutional rights. It's a reminder that bond hearings aren't about determining guilt. They're about managing risk. And in this case, the judge clearly felt the risk warranted stricter control. Cases like this highlight the complexity of domestic violence prosecutions, repeat allegations, and the legal balancing act between presumption of innocence and public safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.